Yes.
I was going to cover in the remaining time available to me two topics, as I indicated yesterday. One is Canadian case law, and the other is fiduciary duties and informed consent, which are the points that are at the back of our skeleton. On Canadian law, I think it's probably increasingly recognised that Canadian authority can provide illustrative guidance, but it's not determinative of any answers. And so no one, neither my friends nor I, has to show that precisely any particular solution it would be applied in Canada. Could I just show you, although you probably don't need reminding of it, the passages in the Gutman Court of Appeal ruling?
Yeah.
Which is tab 40 in the authorities bundle. I'm afraid I don't know which number that is of yours.
7.
7 is being suggested. And paragraph 40, which is page 1762, so tab 40 and then paragraph 1762. There's a discussion of Canadian authority, and the court, this is a judgment of the court, says, having described the submissions on this point, says in paragraph 41, we were regaled with many Canadian and US authorities who said the CAT erred in not following these cases, but they pointed in all sorts of directions reflecting different governing laws and judicial practices, and so forth. Standing back, the value of the data of Canadian authorities has been to assist in understanding the broad scope and architecture of the domestic regime, introduced in 2015, useful in enabling the Supreme Court in merits to clarify some of the central guiding principles. And then there is a page-and-a-half summary of principles which the CAT in the judgment appealed from in that case thought were capable of being derived from the Canadian authorities, and they are illustrative for this case. And I will come back to them because they are a summary. And at 42, the judgment says, for our part, so essentially adopting that description, for our part, we consider it a fair and accurate summary. It might, as case law evolves, turn out not to be exhaustive, but it's a valuable starting point. At the more micro level, how different courts apply their discretion on an array of very particular certification issues under different regimes to different facts is interesting, may have some modest illustrative value, but not much more than that.
You don't have to establish your credentials if you want to refer to Canadian authority. We're interested.
Yes. Well, my point is that it is interesting. It is interesting. It is illustrative, but it can't be determinative because you're looking at a different regime, and that comes out in that summary, which, as I say, I will come back to. So in our skeleton at paragraph 13 and 14, we referred to what Lord Briggs had to say about the Canadian authorities, which has just been summarised in what I've read out, but point out the fundamental difference that our claim is an opt-in claim, which is unknown in Canada. And that's the point the tribunal makes at paragraph 246 of the judgment, which we were looking at yesterday, and is a crucial difference for addressing the conflict issue, because of course it gives us direct engagement with the class. Now, our detailed submissions on Canadian law are to be found in paragraphs 42 to 47 of our skeleton, and I wouldn't be thanked for and don't have time to for reading them out or even trying to summarise them. The high points of the appellant's case, as put to your lordships, seems to be in relation to 2 points. The first is the definition of a common issue in Canada, the success for one class member cannot mean failure for the other. And both Mr. Gill and Mr. Thompson referred to that on day one. And the second point that they make is that the RHA's case is a different one because we're not seeking aggregate damages. And by in an aggregate damages case in Canada, the position of indirect and direct purchasers, if that's a relevant distinction here, need not be addressed until the distribution stage. And we say both those propositions are wrong or overstated. It is true that you will find statements in case law saying, Canadian case law saying success for one category cannot mean failure for another. You have to read the cases quite carefully to work out what they mean by that, particularly when it is clear that in many cases which have been cited to you, including the Vivendi case from which the proposition was taken, the certified class in Canada did include direct and indirect purchases, and there could be problems down the line. So it's clear that when that sort of statement is made, the Canadian courts also require that you take a purposive approach to the common issues, commonality requirement. We cite a case called Elder Advocates in paragraph 42 of our skeleton, saying that is the requirement. You have to take a purposive approach to commonality, which means interpreting the legislation liberally to facilitate rather than stifle its development, the use of class actions as a procedural tool. I don't know who the elder advocates were, but possibly those who knew what Parkinson's law was, to pick up from the Chancellor's point earlier in the week. So what is said here is that this class couldn't work because if the used truck claims fail, that's causing a loss. So it can't mean a common issue. If the pass on is approved, used truck claim fail. Now we say that's not what they mean. It's not what the cases mean when they talk about success and failure. And we cite some cases in footnote 16 of our skeleton. I'm not going to turn them up now, but which show that what they're after is some sense of tangible harm or a net negative effect on certain class members, of which possibly one of the high points is the Paron Alberta case, where success for some members of the class would have meant an environmental case, would have meant that some other class members' homes were submerged under the waters of a lake. That would have been a much worse outcome for them than simply losing on an issue. So that I think is, and I think that point was picked up in discussion. The court was saying, your lordships were saying to my friends, well, it's not a loss if there's if you're on a sort of sliding scale between new and used, you might get lower recovery, but you're not out of pocket. In fact, as I think we will see, even loss for some categories of members of the class is not regarded as a problematic issue. In Canada, the class can still proceed, even if loss. Some members of the class are going to have to be shed because they can't actually get over the line. The important point, probably, and maybe this is where it's worth looking at just one of the cases, is that if the class is going to be certified as having common issues, you're going to need evidence. It's going to have to be proved at trial that the loss reaches the indirect purchaser level. And that's at trial, not distribution. If we look at the Godfrey case, which is tab 59 in the authorities, so I invite the court just to look at that briefly. will be familiar to you, and I think you'll have heard submissions on it before. Tab 59, Pioneer Corporation and Godfrey, which is a Supreme Court of Canada judgment on appeal from Court of Appeal for British Columbia. If you turn within that to paragraph 116, which is on page 2736, you will see, and I think it's really this passage which illustrates or lies behind the summary that we've seen in the Goodman case. The appeal is allowed because against the certification judge's decision, which was on the basis 116, the aggregate damages provisions allow for an award of damages for class members that suffered no loss. And that is because this court has repeatedly affirmed the advantages conferred by class proceeding legislation are procedural, purely procedural. They do not confer substantive rights. And there's some reference there to the well-known cases of Microsoft and Sun Rive. So if, as they say in 117, loss is an element of the cause of action, using the aggregate damages provisions to distribute damages to class members who did not suffer loss would be inconsistent with the purely procedural quality of the advantages conferred by the Act. And it follows that reliance by the courts below on the as it were, option of ordering an aggregate damages award where you were not sure how much loss certain members of the class or whether they had suffered loss was mistaken in the judge's respectful view. So he says that the relevant section, this is over the page, the relevant section is only applicable once liability has been established, otherwise it would effectively confer substantive rights. So what he says is, in order for, in the next paragraph, for individual class members to participate in the award of damages, the trial judge must be satisfied that each has actually suffered a loss where proof of loss is essential to finding liability, as it is in competition cases. Therefore, to use the aggregate damages provisions, the trial judge must be satisfied, following the common issues trial, either that all class members have suffered loss, or that he or she can distinguish those who have not suffered loss from those who have. And then I think it is relevant because this is how the Microsoft case that we all know about for the test. This is how some of it turned out. It remains possible that issues will arise once it is determined that loss reached the indirect purchaser level that affect individual class members' claims. And then he says, how is the methodology going to be, the famous methodology going to be used? And in paragraph 120, it must be borne in mind the trial judge, following the common issues trial, might reach any one of a number of numerous possible conclusions on the question of whether particular class members suffered loss. Might be all, might be none, or it might be some. And that, and only when that has been done, can you go to an aggregate damages, trial, if that's the right word for it. So what these suggest in our submission, on the first of the points that is made against us, is that these paragraphs tell us that the fact that some class members may not prove their loss does not prevent it being a common issue. That's, I think, paragraph 3 of the summary in the Goodman case, which quotes from Vivendi and Godfrey, saying that the important thing is should advance the litigation as a whole. The focus is on the litigation, not the position of individual class members. And we say that the case law in Canada does not show that certification will be refused on a commonality basis, just because there's a possibility that some class members might not prove anything or receive lower damages. And I think I've probably sufficiently made that point.
That's explicit in paragraph 121, isn't it? 121 makes that point very explicit.
Yes. And in relation to aggregate damages, I've probably sufficiently made the point that it's not a shortcut. You actually have to have, in the first place, proved that the relevant class members have suffered a loss. So the respective positions of the direct and indirect purchasers within the class have to be addressed before you can work out who's going to participate in distribution. So it's not the kind of shortcut that I think has been suggested. So
just standing back, the relevance of this is that for the purpose of certification, it would be inconsistent with the regime, you say, if the mere fact that there was commonality which incorporated within it the possibility there would be variable recoveries from 0 to 100%, let us say, that you superimpose upon that a notion of conflict, because that's inconsistent with the regime as it stands, which permits variability within an aggregate damages case by its very nature.
it permits variability within the class.
Within the class.
So as a common issues point, there's a lot of variation within the class.
So it'd be inconsistent to say on that basis that there is a common issue, but we deny certification because there's a conflict.
Yes.
That's the point.
That is the point. Why classes are certified,
But you then have, it doesn't mean to say you don't have to have a procedural mechanism for dealing with an appropriate way to sort out variability.
when you get to the damages phase, you get into the aggregate damages, but only once the entitlement to damages has been established. I think that's what these cases are saying. So I'm responding to an argument that's put against us, which says, well, Canada's very useful and provides guidance as to how these things should work. Here's a new issue. There's a problem with a conflict in the class, and that wouldn't be regarded as a common issue.
I mean, you say in Canada the fact that there is or could be a conflict within the class doesn't prevent it from being a common issue. It doesn't prevent certification.
And
This,
then,
of course, these are aggregate opt-out cases.
yes, because then that's the next point. What's then said, well, it's all different because they're aggregate opt-out cases, but and so all these conflicts can be resolved at distribution. Well, no, it would appear that you have to establish loss first, and only if it can be shown, only if the class member is satisfied that the claimants or the members of the class who go forward to the aggregate damages part of the proceedings have suffered loss, and he can exclude those who haven't. So it's not a complete answer to say, oh well, it's all very different because this is a top-down, opt-out aggregate damages regime.
We're slightly different in this jurisdiction in the sense that the merits can come back to, although prima facie merits don't play a role, they can come back either because you get a strike-out application of reverse summary judgment, or, we have this in FX, it could come in, well, it does at least semantically come into Rule 79.3 on opt-in, opt-out.
Semantic, yes.
And strength of case must include, one would have thought, some analysis of whether there's loss or not. I mean, it could be incorporated within that. But those are the two exceptions to the rule that you don't look at the merits, strength, which would include extent of loss at the certification stage.
Yes. So I think my point is simply that, perhaps not simply, but that when it's said to us that because there is a risk within your class, that some of the members won't recover anything at all, that couldn't be certified as a common issue.
Yes, no, understood.
That goes forward. Then
So it deals with commonality. You say it also goes to conflict.
and then they say the explanation for that in Canada is that these are top-down aggregate awards, and that doesn't seem to be right either, because you do actually have to resolve whether the members of the class have suffered a loss before you can go to the aggregate damages. So those are my particular points on Canadian cases. So bearing in mind that as this court said, what one can use them to illustrate problems. I think it's of course less likely that they're going to provide granular solutions in our particular regime.
Well, that was our word of caution in Goodman.
Exactly.
We had a lot of citation. I blame Mr. Harris for this. Canadian authority and American authority, just on the facts, and that's interesting, but it takes you only so far.
Yeah. Well, I'm just going a step further in saying that on the law as well, there is not only on the facts, but it actually, as part of the Canadian regime, I don't think the points that are put up against us actually work in terms of the Canadian regime. I should say a few words, I think, on fiduciary duties and informed consent, because I know it's of interest to the court. I will try and make it very short, given the timing.
Can I just identify the framework, the context here? I mean, I understand the argument you've just been making, I hope, that the question of the existence of a possible conflict is, you say, not fatal and not even potentially relevant to the certification question. That's what you've just been submitting, I think, which is the fact that you can see that there may be a conflict between various class members shouldn't prevent certification as a jurisdictional matter.
It doesn't prevent it being a common issue.
Correct.
Yes.
But the question still arises, my Lord Justice Green said to you, doesn't it? Once certification has been granted, the CAT's then got to grapple with the question of actually how an identified conflict should be resolved,
Yes.
or at least managed as part of the process, which is where we're coming to now, I hope, which is...
Precisely.
Yeah, okay. So that's the framework. You say over-certification, not relevant certification, but you've got to grapple with it.
We had a discussion yesterday about what stage the proceedings have reached and what will happen next, and the CAT's powers in that connection. Canada, in a way, is a bit of a sideline, but it's said against us that our class is problematic, and in Canadian cases shown one. What I wanted to say briefly now is the scope of any fiduciary duties that the RHA is said to owe to members of the class, which goes to in a sense goes to the existence of it and how it should be managed. So I hope this will at least provide my views on the issues. It's been said that the RHA owes fiduciary duties to class members, and so can't act for purposes of both new and used. And it's been said against this as an actual conflict, and it can't be consented to. This is summarising what's in paragraph 4861 of our skeleton, and attempting to respond to some of the points that have come up. The RHA has accepted in general terms that it is likely to be subject to fiduciary duties as a class representative, but the scope of those duties has not been elucidated or explored or ruled on in any detail. And our essential submission on this is that the scope of any fiduciary's duties depends crucially on the nature of the relationship between the fiduciary and the personal persons to whom the fiduciary owes duties. And that will also depend on the terms of any contract or arrangement between them, and it's a context-sensitive analysis. We cite, and I don't think it'll be helpful to turn it up, particularly given the time, but we cite the Privy Council case of Kelly and Cooper in our skeleton, which was about the position of estate agents who take different clients who may have their job is to present the houses on their books to to prospective buyers, and there was a dispute as to whether one house owner should have been told that the person who just agreed to buy their house had just bought the one next door. So rather remote on the facts, but quite clear in the ruling that the scope of the fiduciary duty has got to be defined by the contract of agency, and that's following the ordering FIPS and other cases which will be well known to your lordships. The relevant context in the present case is that the RHA is acting as a class representative under the Competition Act, and it's probably relevant to remind you, they need remind you, that it's not a member of the class. If it were a member of the class, as a class representative can be, in other words, if it has a claim, has a dog in the fight, that could well affect the analysis, but it doesn't. And if we just briefly look at the underlying rule, which is in tab 3 of the authorities bundle, it's rule 78, the tribunal rule, which goes to authorisation of class representatives. It's page 72 in tab 3. Familiar with this. The tribunal can authorise class rep whether or not the applicant is a class member, but only if it considers it's just and reasonable for it to act as a class representative. And in determining that question, the tribunal shall consider whether that person, A, would fairly and adequately act in the interests of the class members, and B, doesn't have a conflict with the class members, a material interest that is in conflict with the class members, which is say might particularly arise if the class rep is also a member, which is referred to also in paragraph 3 below. So the essential duty of the class representative and the duty that the class representative undertakes is to act fairly and adequately in the interest of the class members. And I think that's a phrase that I used yesterday in the context of what the RHA is trying to do in bringing a claim on behalf of the haulage industry, which includes new and used trucks, because that's what a lot of hauliers use. Now, in my submission, the duty to act fairly and adequately within the class must involve a measure of, or the ability to, as it were, reconcile, conciliate views, diverging views between the class as a whole, and it can't be interpreted, in my respectful submission, to say that the duty of the class representative is to maximise the damages of every single class member. There may be trade-offs which have to apply. You can conceive of a class where every member is exactly similarly circumstanced, and some sort of one-off overcharge in mobile telephony or something like that. Everyone's got the same damages. Sounds a bit like the High Court proceedings there. But in my submission, the duty on the RHA or on any class representative cannot be to have every single class member's best interests at the forefront of its mind, and not be able to take decisions which may involve trade-offs.
That's a pretty remarkable submission, isn't it? That the class rep doesn't have to have the best interests of a member of the class at heart.
It has the best interests of the class at heart, and it can't.
So it can sacrifice the interests of some of the members of the class to benefit others. How does it go about that task?
Well, Lord, it's it's as I was submitting earlier. I mean, it's the role of a trade association, apart from anything else, to try and represent its members in the best
I don't think your
possible way.
submission is improved by saying it's a trade association as opposed to it being a fiduciary.
No, but its role in both contexts may involve, as I say, sort of conciliating between different
How does it do it?
by an exercise of judgment and
So what biggest, most influential members have the most say, and the small operators can lump it?
well, that's plainly not the approach that's been taken here. But no, it's got to act fairly. And
What's your frame of reference for fair? Because fair is just a meaningless word without a frame of reference.
it has to advance the interests of the class as a whole as best it can.
How does that? It is a very difficult test to apply in all sorts of areas of law where there are differing interests within the class. I mean, it's notoriously difficult in company law to just simply say you advance the interests of members of the class when the class, on certain issues, have rival interests or to be served. I mean, it's fine if you identify a common interest, i.e. getting the maximum damages out of the manufacturers. But if, for example, it comes to distribution, let's say, where £1 more to member A is £1 less for member B, what's your frame of reference to say, you know, how does the RHA make that judgment without some sort of procedure in place to resolve the conflict? It can't just sort of do what it thinks is
Absolutely.
right. I mean, how what's the mechanism to deal with that?
Well, I think there has to be some degree of levelling around or aggregating. I mean, if you take Merrick's, for example, and you've got 46 million in the class, you can't take account of every individual. There's got to be some groupification, if you like. At some point, ultimately the CAT has got to identify groups, and it has to approve settlements, and it has to approve distribution. At some stage, there has to be some mechanism for dealing with, even in broad terms, directly conflicting interests.
I mean, everybody knows there'll be a little bit of rough and readiness around the edge. We've already been speaking many times about the broad axe, and this is not an absolute science. I fully understand
Of course.
that.
No.
But simply to say, trust us, we're a trade organisation, we'll make a judgment as to what's in the interest of the class, just doesn't actually address the real question, which is, if you have members of the class whose interests in a material sense are opposed, what's the technique that is used within the RHA to make that decision? I mean, I'm trying, in many ways, this is in the interest of the RHA to identify the problem and put something in place to deal with it, because otherwise it's just storing up the possibility of real dissent and criticism and dissatisfaction from within the class if all it says is, well, at an appropriate time we'll stick our fingers in the air and decide what we think's right.
But that's not exactly what I'm saying, Lord, if I may. Firstly, we've already discussed in some detail the approach which the RHA intends to take, and we have had exchanges on that with the Davis methodology and so forth, which is intended to represent to the best of his views and his abilities the position of the class as a whole.
And that's, of course, and nobody doubts his good faith. I mean, everybody has said nobody doubts his good faith. But the reality is that with any sort of economic regression analysis, inevitably is dependent on what the data is that's input. And there may be what might be described as unconscious bias on Dr. Davis's part in favour of one one side rather than another, even if he doesn't, in circumstances he doesn't even know that that's what he's doing, and that's why the concept of having some separate subclass with its own legal representatives and its own expert seems to me at least to be entirely appropriate. And what I'm slightly surprised by is that you haven't really picked that up from the discussion that the court's been having with the other parties for the last 2 days, because that is really where our concerns lie. And if the RHA can deal with that from within its own organisation, whether it has the facility within the RHA to say, well, we can set up a Chinese wall, there can be a separate class representative within the RHA to represent the used purchasers on these issues, not to have to be on everything.
No, but
With its own separate firm of solicitors and barristers and experts, then that's fine. But you don't seem to be trying to address that. You seem to be trying to say, well, don't worry, we can deal with all this through Dr. Davis. We don't need to worry about conflicts.
well, my lord, I probably not made myself clear. That is the first stage. We have said, we have committed, we were discussing this the other day, that if the conflict arises, is deemed to arise, if the conflict is said to arise in a sharp form, we have committed to setting up what I've called for shorthand the clean team. I mean, that's on the record.
But doesn't that have to be grappled with at a fairly, well, at a pretty immediate stage? Because not only are you going to be going out to the class members with a notice telling them how this question is going to be resolved, but also you've got to ensure that the funding caters for it. I mean, those are two immediate questions. I mean, the points that have been raised in argument, which we, speaking of myself anyway, I'd like to hear some answers on, are what are you going to tell your members when you ask them to sign up about how this problem will be addressed? And the notice at the moment in draft reflects the CAT's first reason for saying at 246, 247, actually this can just be addressed by informed consent and trust Dr. Davies, which we've already sort of indicated, certainly myself, I'm struggling with. Second, if there needs to be identification of the mechanism to resolve the question as between new buyers and used buyers, that needs to be identified in the notice, doesn't it, for people to sign up to that, because it's only by giving them that information that you'll be giving their informed consent to that proposal, unless you're planning to go back to them again later on in the process. And then haven't you got to, at the start, because this is relevant for certification, I think, it's where the line becomes blurred, you've got to have a funder who is prepared to fund this conflicts process involving your clean team. And I would have thought commit not to interfere. The point was made in settlement or otherwise on the resolution of the conflict. You know, that I'm not saying this is insoluble. It doesn't seem to be insoluble, but it needs to be thought through. And at the moment, I'm not hearing the answers.
Well, my lord, in a sense, it's going to depend what your judgment is. The notice is on hold. The CAT has indicated what it thinks. You may.
Do you have any instructions on the two issues that we've just raised? One is, does the RHA have the facility within its organisation to set up a Chinese wall kind of talk? My own guess would be, but it's no more than an educated guess, that it does, because it's a fairly major organisation. It's not just sort of two men and a dog in a back street in wherever it is. the funding issue is actually something on which one would expect you to have taken instructions so that you could say to the court, well, the funder is prepared to not to interfere in relation to the conflict. Because as a matter of standard, we were shown a passage in the funding agreement. It does seem to be rather open-ended.
Well, Lord, I repeat to this court what I said at the court below and is reflected in the judgment. That the RHA commits to having that separate team. It is able to erect a Chinese wall and appropriately staff up and instruct solicitors to represent the subclass if one is needed. So that can be done.
So just to be clear, the point was made that what's I think in the judgment suggests that the RHA would instruct either a separate team within the law firm it currently, in other words, that puts the Chinese wall in place within the existing law firm, and divides the people. But it was unclear to me, both from what was said yesterday and indeed the judgment, whether the RHA itself has the capacity to split its corporate self into two teams, you know, of individuals who, on these particular purposes, give their undivided loyalty to one side or the other in running the dispute or in any settlement negotiations. So at what level are you saying? I mean, if you're saying the RHA will just instruct a different firm of lawyers, that doesn't quite, I think the argument is, solve the problem, because you've got to split the RHA. Your opponents say the RHA can't split itself.
Yes.
Now, I'm not sure that's right, because we were shown an authority which was dealing with a solicitor who can't split his own single mind.
Split his own mind, yes.
But the question is, can the RHA as a corporate entity put a structure in place to deal with this question?
Well, then yes, it does. It does. It is a large, you know, relatively well resourced, although no doubt economically run organisation. It does have the capacity. It could set up and obviously is prepared to set up the separate team and have that team appropriately represented by lawyers. And in relation to the funding, when the funding is there to cover both new and used such as is. So you know, the funding has been, as I said before, it's been a long road in this case, and the funding has continually matched the needs of the case.
And how does the, assuming the funding is there to have two teams, in other words, in amount, is there a response to the argument against you that you're also going to need to ensure that the funder doesn't have the ability to require settlement because, as it were, one group is, the deal favours one group over another for the funder's purpose? What influence does the funder have over resolving this conflict in terms of settlement, was the question.
The funder can't come in and interfere with the process. So if a settlement offer is made, then you've seen the provision, but the funder plays no part in discussing the mechanics of any.
I'm not sure for myself. I am fully on top of those provisions of the funding agreement. Some of which we didn't actually see because they were redacted. I'd appreciate actually an explanation as to where the lines are on the agreement we've got.
I mean, if the reality is that the funder has no right to interfere under the terms of the existing agreement, then that's one thing, James. And certainly from what was shown, albeit most of it was blanked out, that doesn't seem to be what the agreement said. I mean, the obvious point here is that you talked about fleet owners, for example. the fleet owners, the big boys, as it were, are all going to be, I say, likely to be new truck purchasers. The used truck purchasers are going to be the smaller one-man bands and the SMEs and so forth. And therefore, in terms of the overall class, they may have less clout than the fleet operators. And what we're anxious to have dealt with is a potential conflict between those two groups as a result of this issue, even though overall they've got a common interest in establishing there was an overcharge at the outset, if I can put it that way, and also in ensuring that the funder can't, as it were, side with the fleet operators in a way which is prejudicial to the smaller operators in the other subclass.
Yes, well, my lord, I'd have to turn up the provisions of the funding agreement, which I'm afraid I haven't got in front of me. But I can do that shortly. As you say, the fleet operators are the ones who have the most trucks, but the used truck operators are the most in number, and they're members of the RHA, and the RHA is a membership representative organisation, which is, as I've said, used to trying to conciliate all the differences between them. So I say, and I'm only going to say it for the association, that it has their best interests at heart. It has 14 directors and instructors, so there can be a subcommittee of the board to deal with the Chinese wall situation. And I'm going to have to take, I think, separate instructions on the funders' ability to deal with the settlement document.
I think it boils down to this, that if the CAT says to you, we want comfort or satisfaction, I think it's really on three things. This is before the event, of course, with us, but are you going to be able to satisfy the CAT that you can secure separate representation for any group that the CAT considers needs separate representation? Are you going to be able to satisfy the CAT that there is adequate funding for that? And are you going to be able to satisfy the CAT that there would be no improper external pressure on litigation decision-making, including settlement? None of those may be absolute, because no litigation is completely with unlimited funds or without pressures. But the CAT will want to know, I think, at those three levels, whether or not there is adequate facility which can be put in place at a new case management hearing, which satisfies it that if and insofar as the problem arises and the CAT so decides, the mechanism is there. You say you can put up separate representation. It may be that it could be done internally through Chinese walls, or it may need to be done through external representation. You say you've got funding, and because it's covered at the moment, but there will be incremental costs if you have to do this. And then thirdly, CAT's got to be satisfied that the mechanism set up won't interfere unreasonably with ordinary independent decision-making in the litigation, which would include settlement. So it may be that the funding terms would need some sort of modification to take that into account.
Indeed, well, possibly they have on previous occasions as well. So, I mean, all of these issues were anticipated and somewhat ventilated in the tribunal below. This tribunal came out, as you have seen. We're now in an appeal, and it will depend on what the court says, and if it considers that the CAT wasn't sufficiently vigilant, then the matter may have to be reconsidered and will be put to proof of the representations that I made on instructions that such a team can be set up. And I haven't got the funder here, but the funding has been flexible, has met all the budgetary contingency, the forward budget has been regarded as entirely satisfactory, up to date, and the funder,
Well,
I may say,
ultimately,
has
as my lord
shown
says,
a lot of forbearance over
Yeah.
the past 5
Ultimately,
years.
as my lord says, these are matters for the CAT. The CAT will have to be satisfied about.
Yes, and as it will about the notice fund, and that's we're in a sort of I won't call it limbo, but obviously these issues are now being ventilated professionally, and we will have to we await your judgment.
Well, this is one of the strange things of actually having no order, which is an appeal against, because presumably the certification order would have certified on certain bases. Does the certification order, should it address the question of the notice?
I mean, the publication of the notice is obviously a requirement in the CAT's rules, and it has to order the publication of an authorised notice.
So that's part of the certification order.
I mean, the other thing is, it's unclear from the rules whether these matters go to certification or are steps to be taken after certification. Rule 81 says the class representative shall give notice, so it rather presupposes that certification has happened. But in an order, it may be academic.
It does, but what the class representative is required to do is under the supervision of the CAT.
Oh yes, absolutely.
The ongoing, and the CAT has made it clear on many occasions that it is empowered to, and if necessary would, change the scope of the CPO, which would itself
Yes. Oh
require.
yes. The sort of damages always hangs over this.
I feel it's right behind the back of my neck at this moment.
Okay, right.
So I'm told, and maybe will or will not want to turn it up, that there is a draft order, which has not been a draft order following the proceedings, which is in the supplementary bundle at tab 2.
No, we've seen that, but
Well,
I
and
did-
indeed the draft notice.
We've seen the draft
the
notice.
point
yeah.
my lord's making, and I'm afraid it chimes with all members of this court, is normally we hear appeals against orders. And we don't see why the position should be any different with the CAT than it is
Well,
with everything else. And if the order hasn't been agreed, it jolly well ought to have been.
Well, I fully accept that.
It's nearly 6 months since the judgment.
We were suggesting to the CAT that an order was needed, but they have stayed everything, and that's where we are now.
You
Right.
see, one part of the order that is not open to dispute. I mean, we've got a colourful. Well, sorry, I've got a colourful electronic version of the order. It's black and white in the bundle rather than helpfully. But the colour version shows the disagreement, as I understand it, between your clients and the respondents as to the form of the notice. But what isn't in dispute, as I understand it, because it's in black, is the basic message derived from paragraphs 246 of the CAT's judgment, which is, on this one, Mr. Used Truck Owner, you just got to trust Dr. Davis as expert and the RHA guided by him, and you can't, that's it. No, just no complaint. He'll act as, doesn't say this, but he'll act as expert, not arbitrator, and you basically, that's what you get. Well, if that's not satisfactory for reasons we've been exploring, and there needs to be something else, then that part of what would have been the CAT's order would need to be overturned.
Would need to be amended. Of course, probably be back to drawing board on the draft notice. Depending on what your
So to that extent, you'd say this doesn't affect the decision to certify as such,
No.
but it's an immediate consequence of the rules that this needs to be addressed in a different way from the way that the CAT addressed it at paragraph 246, 247, and as reflected in the draft order and notice. That's where I'm sort of at in the structure of
If
things.
you so rule in this appeal, that's correct. That I think follows. And as I said, be back to the drawing board on the order and on the notice. And we may have to activate our commitment to set up the clean team. So that may have to be done sooner rather than later. Depending on where you come up.
Okay.
My Lord's taken, well, it has taken much longer than I think I was told for. So
We have been challenged.
so unless I can assist further at this stage.
No, it's fine. Thank you very much.
Thank you.
I'm sure what Mr. Pickford's standing up for. I'll let him say
My
something.
Lords, I hesitate to raise. The reason why I'm standing up now is I'm last on the bill.
Yes.
And the agreement that we reached between council depended on me getting about 25 minutes to make some reply submissions. There are still some important points in my submission that reply does need to be made on, because although I can see where the court is going on certain respects, there are some points where Mr. Flynn seems to have persuaded you where I would like to have the opportunity to persuade you otherwise. And so I rise now because I want to make sure that I don't just sit here and then we get to 1 o'clock and
Well,
I don't
the
have any
position
time.
is this. I said we would finish at 1 o'clock.
Yes.
The timetable that you seem to, the timetable we talked about yesterday involved Mr. Flynn having half an hour. He's had effectively an hour.
Yeah.
Because we came in 5 minutes late. So on that hypothesis, you ought to be able to, between you, finish by 1 o'clock or soon thereafter.
I hope so, my Lord.
So we will sit until you finish. But once we get to 1 o'clock, the bad-tempered clock will start.
I understand, and because it's the bad temper clock for me, that's why I thought I'd just make the point now. Thank you.
My Lord, I certainly don't want to take up any more time on timing issues than absolutely necessary. But your Lordships will be aware that this is my appeal. I've been sitting patiently after making my submissions, I think, in 2¼ hours. And given the way the hearing has gone, I indicated to my friends that I would need an hour, but given leeway for possible questions. But I will do my very best to stick to the 3/4 of an hour that I agreed when I thought this was a 2-day timetable. But in that spirit, I will take the issues on ground 1 as shortly as I may, although there is a distinctive position that we have on ground 1. But I'll need to deal with ground 2. It would assist me whether the court will be interested in the respondent's notice, because if I've got to deal with that, then I have to deal with expert issues and Dr. Lillico's evidence and various, what I would say, quite inaccurate statements made about Dr. Lillico's evidence. But if in fact your Lordships weren't particularly impressed by those challenges, then I can obviously take it more shortly. But I don't want to waste time debating that question now, but if there was any indication, that would assist me in planning my submissions.
Well, we ought perhaps have a short break anyway. Perhaps the court can discuss that and we'll come back and tell you. Does that seem sensible?
Yes, subject to losing a bit of time
Well,
between now
5
and 1
minutes, we're
o'clock.
going to have a
We're
5
going to have
minute
to do it
break
at some
anyway.
point. So perhaps that's sensible, my Lord.
So now would be as good a time as any. So we'll have 5 minutes.
Yeah, that's fine. No, that's right. I think that sounds quite good.
That's what. So
I'll
refer to.
yeah, no, I see.
Okay. Do you want a bit of water then?
I'm good, thank you.
There's a second bottle here.
Thank you.
Which you
Thanks.
Hi. We have additional copies of the justices. So this is for bundle D, which are authorities. Three sets for each of one for each of them. Thank you so much.
Mr. Thompson, the court thinks that you should concentrate on grounds 1 and 2.
I'm grateful, my lord. I may stray briefly into a flourish, but I'm grateful for that indication, my lord. Mr. Flynn started this morning with some reference to Canadian authorities, and I think my response can be very short, and it may be that Mr. Jowell or Mr. Pickford want to say something more. In my submission, the outline position was determined by Lord Briggs at paragraph 42 of Merrick's, which is tab 26, page 1070, and I'm sure your lordship's aware of it. And in my submission, Canadian law gives little detailed assistance on this issue, but there are 2 points of principle which appear and were originally derived from Canadian law, we would say are entirely consistent with principles that should apply anyway under the CAT rules and the equitable doctrines relating to fiduciaries, and in particular rules 78.2a and 79.1b. And the 2 principles, if I can call one the Vivendi principle, that success of class member X cannot lead to the failure of the claim of class member Y, and that was reiterated in Godfrey at paragraph 105, A11, 59 to 103, I think, my lord. And secondly, the well-known Microsoft test, which your lordships have considered and given guidance on in a number of recent cases. And it seems to me that's all I need to say about Canadian law, that we got two principles from it, but it's now been subsumed into English law. So the first area is whether or not the submissions you've heard from the RHA resolves the conflicts issue, and we say no. The conflicts issue has not been resolved for a series of reasons that have been explored in argument. The draft notice, which we've just been discussing, makes the highly unsatisfactory and unresolved nature of the current position extremely clear. Likewise, we submit that the CAT clearly erred in law in considering that the giving of a notice could resolve the actual rather than potential conflict that arises here, both on the RHA's pleaded case and the expert evidence. And my Lord Justice Green made that point in relation to the second half of paragraph 247 of the CAT judgment. The RHA has, to be fair, not even tried to answer this point, either under the statutory regime or in relation to its position as a fiduciary. We say it's nothing to the point that the reason why used trucks are alleged by Dr. Davis to be more expensive is because of a broad economic effect of the cartel, or possibly because some involvement of intermediaries, well, that was rather unclear to me. There is still a reduction in the damages payable to the new truck member if it is proved on behalf of the used truck member that the new truck member received a higher price than would otherwise have been the case on the sale of its truck. And Dr. Davis made that expressly clear at paragraph 194 and table 27 of his first report, which your lordships will have seen, tab 10, pages 173.1 and 177. Now, there is a very important point, which I have been the recipient of numerous emails during this hearing from Dr. Lillicoat, that, and if I may express it as best I can as a lawyer rather than an economist, that in a case of this kind, there is no common pie, and there is no presumption that the larger the pie for the new truck buyer, the larger the recovery of the used truck purchaser. And the reason for that is particularly clear in this case because of the approach that Dr. Davis has adopted. There are two separate calculations conducted independently, as Mr. Pickford said in his opening submissions. The used truck recovery is not a proportion of the new truck recovery. In theory, at least, it could be equal to or even larger than the new truck's result. For example, if the new truck regression failed, but the used truck regression succeeded. And so there is an agreement built in, baked in to the pleaded case and to Dr. Davis's methodology that the new truck purchaser will have their damages reduced by reference to the results of Dr. Davis in relation to used trucks, whatever they are.
Can you just give, I mean, I don't want to delay you very much, but I did find that that's a new, how could it be the case that there's no overcharge for new trucks as a result of the cartel, but it's found that there is an overcharge on the purchase of used trucks? In other words, the price of a new truck is not increased as a result of the cartel. That's what I think you meant by the new truck's regression failing.
But all I'm saying is that it's a theoretical possibility. There's
Well,
no,
give me the theory. I mean, I don't
there's no
understand.
relationship, and one sees it at table 27, which I'm sure you'll
I understand that you say there's no direct relationship, but I find it almost impossible to understand the concept of saying that the result of the cartel was that the price of new trucks didn't go up, wasn't increased, but somehow the price of used trucks did.
My lord, I'm not saying that is in any way a likely outcome.
No, but you said it was a theoretical possibility. I'm just trying to
It's not
understand.
a likely outcome, you needn't worry about it.
Well, my lord,
I mean, the reality is that there are two ways in which the used trucks could, the cost of the used trucks could have gone up. One is the overall effect of the cartel, what we might describe as the umbrella effect, which we discussed yesterday, which is that the effect of the price of new trucks going up means that there's a reduction in in demand for new trucks and people want to buy used trucks and therefore the price of used trucks goes up. The other is the pass-on point, that the owners of the new trucks, when they sell them, pass on part of the overcharge to the used truck owners, who therefore pay more than they would otherwise have done. But in both those examples, the position in relation to used trucks is entirely dependent upon there being an overcharge on the new trucks in the first place.
Yes,
Otherwise we wouldn't be here.
all I am saying, my lord, is that the way that the RHA has chosen to proceed is to have a freestanding claim for used truck purchases, both on the pleadings and in an expert report. But that is not expressed as a percentage of the recovery of new truck suppliers. It's simply the one minus the other. So there is a systematic negative correlation between the recovery of the used trucks, which is conducted independently by Dr. Davis, and the recovery of new trucks. It's simply deducted the one from the other.
I understand the proposition that this isn't just a question of how to divide a finite pie between new truck owners, purchasers and used truck owners. I get that. I understand that. But I don't understand the proposition that says that if there's no effect, if this cartel had no effect on new truck prices, there could nevertheless be an effect on used truck prices. That I find
No,
is a
I'm
different
not
point,
going
and
that.
that's what I
I'm
thought
not going
you said.
that far, my lord. What I'm
I
saying
thought
is,
that's what you did say.
well, the more complicated point that Dr. Lillico makes, that we put in our skeleton at paragraph 38, is that you could have an economic model that was beneficial to used truck purchasers, but that actually was somewhat lower, implied a somewhat lower percentage at the new trucks purchasers. And there's no inconsistency between the two. That the used truck purchaser is simply interested in its recovery. And the way it's been formulated by Dr. Davis makes that particularly clear, because the bigger recovery made by used truck purchasers, the lower recovery by the new trucks purchasers. I'm sure your lordships will want to think about this, but that's the submission, and I don't want to get bogged down too much in the debate. If I could move on to the other problem, as we would see it in Dr. Davis's approach adopted by the RHA, and there was some discussion of this yesterday, and it appears to us that the sort of, I was going to say tablets of stone, but I'm not sure that's appropriate, but Dr. Davis would come down with his results from the used and the new, and they would be simply declared. But that is either a naive approach, or else, and it seems to us that it's quite possibly more realistically seen as a somewhat desperate attempt to respond to the conflicts that clearly arise within the RHA class, suggesting that his results will be immutable and independent of the instructions and evidence that they're based on, or, as I think my Lord will Justice Green, the economic models that he chooses to use. And we would submit that a very good example of this, which doesn't involve any complicated issues of data or economics, was provided by Mr. Flynn himself in his reliance on Royal Mail, where it's clear that the CAT was influenced in its conclusions not only by the weak evidence of Professor Nevin on economic grounds, but also by witness evidence recorded at paragraphs 518 and relied on by the CAT at 547, and that's at tab 46, pages 2115 and 2119. And in my submission, the court has to ask itself, first of all, this question, but also why Mr. Flynn didn't offer any answer to the question: how could the RHA decide whether or not to call such a witness, whose evidence could be fatal to the claims of UPCMs, or used truck purchasers, but also help to defeat any mitigation defences of the manufacturers that might be advanced against the new truck purchasers as they were in Royal Mail? So that then takes me to my second area of submission, which is the position of used truck purchasers and new truck purchasers. And the court expressed concerns to me in argument on the first day about the position of used truck purchasers if the RHA were to cease to act for new truck purchasers But my submission is that the position that's emerged is in fact the converse. The RHA has already been certified as a suitable class representative for used truck purchasers on the basis of its pleaded case and expert methodology. There's no basis for any appeal against that aspect of the tribunal's ruling, and there is no conflict for the RHA, Mr. Davis, or the legal team as against the used truck purchasers. They have a unitary claim which is not in conflict with anyone. Secondly, and I think this was a point of concern to the court, understandably, it's not been suggested by the RHA that its used trucks claim is not independently viable. Its evidence is that although the majority of its trucks were purchased new, about 70% of its class purchased at least some used trucks, approximately 10,000 claimants, and they purchased over 85,000 trucks. And again, Mr. Flynn expressly distinguished the factual position in Royal Mail and BT, where the trucks seem to have been pretty old, as atypical. And in fact, this is confirmed by Dr. Davis in his own sampling evidence. And given the time, I won't take up time, but he gives some quite high values for quite new trucks at tab 10 of the supplementary bundle, page 150. So our submission is, the factual position is that the RHA is not only a suitable class representative for used truck purchasers, as the CAT has correctly found, but in fact the only suitable class representative for them. There's no appeal against their suitability to represent used truck purchasers, only against their representation of both new and used truck purchasers.
But there's no evidence, is there, or was there any evidence or any finding that they have funding, for example, for a claim solely on behalf of used truck purchasers?
I'm not sure if that's a problem for me, my lord. I mean,
well, we went around this circle yesterday. They're in the saddle. You want to unseat them, and isn't it part of your submission that they could viably continue to represent used purchasers, used truck purchasers? I mean, that's what you're suggesting, isn't it?
I think for me, it's more a matter for my learned friends in the middle here as to whether they would reopen the funding issue in relation to the RHA if it was limited to used trucks. I don't think there's anything on the face of the funding agreement that would call it in doubt. Indeed, there are some quite low recovery figures in the funding agreement, which leads to certain percentages for the funder. But I think they go right down to recovery of £1 million, which in the present context is a small amount of money. But
that's £1 million across both classes at the moment. I mean, the simple point is you say you don't have to have evidence that it could be funded. It's not part of your case.
No, I mean,
you need to establish that.
It appears to me that not only were Mr. Flynn's evidence on the hoof this morning something that could possibly have been anticipated, given that this case has been on foot for 5 years and the hearing was in 2021. But also, if there's a problem about that, he might have made some submissions about it in the last 24 hours as well. I don't think I can really be expected to go behind that. It suggests he doesn't regard it as a bull point.
Well, your point is that if what he was saying, if what the RHA was saying is no, simply acting for used trucks is not viable because we wouldn't get the funding, we would expect them to have said so.
Yes, indeed, exactly. And as I think I made in opening, I'll take it briefly, that Rule 87 of the CAT rules makes it clear that the RHA would need the CAT's permission to abandon its role as representative for used trucks. And our basic submission is that we think that would be contrary to the statutory objective and to the CAT's own judgment, given that the limitation has now expired for anybody else to act as class representative. And finally, and I think this is really Mr. Flynn's position, Section 253 doesn't offer a satisfactory fallback position, but the reality of the situation is that the RHA, Dr. Davis and the legal team up to and including Mr. Flynn or already the used trucks team. What is needed is an independent new trucks team. So if I come to the position of new trucks, we say that that requires careful consideration in the light of the conflicts issue. And as I've already said, we say that the RHA's pleaded case and expert evidence advances a positive case on resale pass-on as the basis for the used truck claim that's equivalent to conceding that issue to the manufacturers by way of defence for the new trucks claims, notwithstanding the clear prejudice to the new trucks claimants. And then we've made another point, which we made before the CAP, which is also an issue which is important, is that the RHA class definition for new trucks is artificially constrained by the fact that it's based on new trucks used for road haulage purposes. And one sees that in the class definition. So there's a substantial class of new truck purchasers for whom the UKTC was proposing to act, but that's been excluded from the RHA claim altogether, notably purchasers of trucks to be used for rental purposes. There's no basis for this court to find that those claims, on behalf of this class of purchaser, many of whom are relatively small businesses, is less significant or less worthy of protection than the used truck purchasers, who are already represented by the RHA in accordance with the judgment of the CAT. And we say, from the perspective of the statutory objectives, the exclusion of that class is something that should be taken into account, for example, by reference to considerations at paragraph 2 of Merrick's, in particular the deterrent effect. And we say that if our class was certified, as I think was put to one of the other advocates, I'm afraid I can't remember who, in argument, the new truck purchaser members of the RHA class would all be protected by they being represented by UKTC as an independent class representative whose application has been found by the CAT to be satisfactory. And for that matter, we would be proceeding on the basis of an opt-out aggregate award, which has certainly been sanctioned by this court and by the Supreme Court in a number of cases. And we do say that there is at least a class of small operators, in addition to those who aren't represented at all, who would be fully entitled to a share of distribution out of an aggregate award, but who may well have insufficient motivation or access to legal advice, enabling them to join an opt-in class in respect of damages suffered by them between 10 and 25 years ago. Those people might be a particularly deserving class, particularly in relation to the trucks purchased in the last century or in the first 5 years of this century, and they might have a significant claim in terms of damages and interest. But they're probably the least likely people to join the RHA claim. The third topic I wanted to look at was the strategic position of the manufacturers, which was an issue that was raised in discussion with the representatives of the manufacturers in argument yesterday. And we would say whether or not it's fair to describe their position as Machiavellian, and whether that would be taken as a criticism or as a compliment to them, it's important to be realistic about their strategic position as defendants facing substantial liabilities arising out of their admitted participation in a very large EU-wide cartel lasting for 13 years. We say the only reasonable assumption, both under competition law and under the CPR or the CAT rules, is that they are rational commercial actors that are acting in their best commercial interests to minimise their financial exposure to their direct customers, i.e. to UKTC's proposed class members. As explored by the court in argument, there are very sound commercial reasons for the manufacturers to seek to promote the weakest possible collective claims against them, i.e. an opt-in class of a subcategory of new purchasers with a discount of their claim baked into the case based on pass-on, both in their pleaded case and their expert evidence. And we say that any such preference of the cartelists, however reasonable from their point of view, would be directly contrary to the statutory objectives identified by Lord Briggs in Merricks. And there's another aspect to this, relevant to several of the issues raised fairly bullishly by Daimler yesterday. It is worth reminding oneself not only of the nature of the admitted cartel, as described by the Cat in Royal Mail, applying earlier guidance of the Court of Appeal, and the description is at pages 1933 to 1945 of tab 46, but also the nature of this product. UK registered trucks, and large UK registered trucks, are a highly regulated product market where each new truck is separately registered for use on the UK road network. The proposed defendants accounted for a very high proportion of the total UK sales throughout the cartel period, and there's at least a strong argument that their conduct affected the entire market. As such, there should be comprehensive data for the UKTC new trucks class, going back to 1997, both from public sources and from the manufacturers in relation to the sale, covering such matters as list price, registration, etc., as well as, of course, the operations of the manufacturers themselves and their distribution arrangements, as well as access to witness and documentary evidence relevant to a host of economic issues. In my submission, and it was something that concerned the Cat in Royal Mail, if the manufacturers were to sit on their hands and avoid pleading various issues for fear of having to give disclosure, then the Cat would be entitled to make adverse inferences, as it did in Royal Mail. And we also say that any suggestions of a lack of data to support detailed expert economic analysis in respect of new truck sales, which you would think would be the thing that the manufacturers would have most interest in and most precise records of, advanced by admitted cartelists, who would be the principal sources of such data, should be met with the very considerable scepticism, and that this is actually a factor that we took into account and that should be taken into account in considering whether or not an opt-out claim for new trucks purchased directly from the cartel is not a very worthwhile type of collective proceedings to put forward. And those were the main points I was going to make on grounds 1 and grounds 2, but I would like to make a very brief foray into the expert issues, just to set the record straight, if I may, on behalf of Dr. Lillico. But given the time and the indication from the court, I think I can do it primarily by reference to the amended reply, which was the document that we put in shortly before the hearing, and that's at the second supplementary bundle, tab 21. And it's two passages, my lord.
Sorry, second supplementary bundle.
Tab 21.
The supplementary bundle.
Okay, so sorry, the supplementary bundle, it's the second one I have. Sorry, my lord.
Sorry, yeah.
Okay, it's the supplementary bundle, tab 21.
Yeah.
And the first passage is paragraphs 13 and 14. Where there's a description of the UKTC application, both the nature of its class definition, but also in particular at 13.4, the position that the UKTC took was that issues of pass on to indirect purchasers are for the respondents to plead and prove in defence to their claims. Although the respondents and apparently the objectors assert their intention to plead in defence of mitigation, there is scant detail of what that defence will be. UK responds to what limited detail has been provided below, and then there's a footnote setting out what we understood to be the case at this point. And then the second passage, which is somewhat longer, but it will enable me to take the matter very briefly, is the section where we respond to criticisms of the UKTC's expert evidence, which is section B3, which is page 20 of the amended reply, but then pages 793 and following in the reply. And it's quite a long passage that goes all the way through to page 805. And it addresses both the general criticisms made of Dr. Lillico, but also the more specific ones. And in particular, there is a series of criticisms, some of which will seem rather familiar to your lordships, because they're basically the same old criticisms that were made before, which Mr. Harris has seen fit to regale your lordships with yesterday. And they are the points on page 800, subparagraphs 4, 5, 6, and 7. And we respond to those points at paragraph 75 to 78. And in particular, we point out that the suggestion that reliance on econometric evidence as well as simulation modelling was dealt with in his second report, and indeed had been dealt with in his first report. So the suggestion that he hadn't thought of it and he dreamed it up on the hoof in the oral hearing is really an extraordinary submission to be made at this stage. And the position in relation to pass on is set out at paragraph 77. And in particular, we make the point that pleading pass on might well increase rather than reduce the overall exposure of the cartelists to litigation, and also that there's a possibility of volume effects, referring to paragraph 218 of Sainsbury's, and also paragraph 1.14 of Dr. Lillico's second report. And I think we should just look at that, because it's alleged that Dr. Lillico was apparently blindsided by the whole issue of pass on at the oral hearing, whereas in fact that's obviously not true, because it was raised in response to his first report and he addressed it in his second report, and that's at tab 15. Of the supplementary bundle.
Yeah.
Page 468. And it runs through to 470. And he makes various comments on the issue, both procedurally, that on the second paragraph on 469, that it was mainly the matter for later phases, and in particular for the cartelists to raise if they seek to argue that any losses caused to the claimants were passed on in higher charges to their customers. So it's simply not correct that, as it were, Dr. Lillico hadn't addressed this, and the tribunal was satisfied, both on the basis of his written and his oral evidence, that he'd done enough to pass the Microsoft test.
The CAT accepted that both his basic model and or his basic model using regression analysis as a sort of health check were sufficient.
Yes.
You need to go much further than that. The CAT accepted his analysis. They may have preferred Dr. Davis, but they didn't reject his approach.
No, there's only one other point I wanted to make, which I haven't, I think, made before, which is, your lordships were shown the Gormson case. And in Gormson, you may remember it's the Meta case,
Yeah.
where the CAT was totally dissatisfied with the expert methodology on the basic question of how you analysed Meta as an entity, whether it was a one or two-sided market, and they found that the expert had completely failed to address that. And what they did was not to dismiss the CPO, but to give them 6 months to try and come up with another theory. So in my submission, Mr. Harris's position is not only hopeless on the sort of Knapp and Gutman approach, that it's essentially a Wednesbury attack on a perfectly reasonable decision of an expert tribunal, but also on the basis that even if it had been correct on the hypothesis that the CAT had not been satisfied with Dr. Lillico, the correct response would at least to have considered demanding that he should go away and prepare something on pass-on. Though in my submission, very much for the reasons put in argument by my Lord Justice Snowden, but also in the NTN judgment of my Lord Justice Green, there is something somewhat surreal about the whole debate, given that not only is this a defence that's been unpleaded, but the primary defence of the manufacturers is that there was no overcharge. And as I think was made in various places in NTN, there is a strategic problem with the entire defence, in that if it were to be demonstrated by the cartelists, there would be an acute risk, not only of debates about volume effect and pass-on generally, and possible claims from, for example, used truck purchasers and possibly other people like Merrick's, but also the fact that in order to get the case off the ground, they might have to give evidence about why they thought this overcharge was likely. And they might very well not wish to make disclosure. That point was made both by the CAT and by the Court of Appeal in the NTN case. So in my submission, there are some
Same
very
point was
serious
made by the
problems.
CAT in RM.
It's the same point, isn't it?
Yes.
That they-
And then I'm aware of the time, so I'll just, if I may say something very briefly about grounds 3 and 4. I'm aware that ground 3 took some heavy punishment from Mr. Singler and to some degree from the court. I'd simply say that the indications from the court in Gutman, paragraphs 55 and 56, about what constitutes an error of law, first of all, the overall high-level approach the CAT should take, and secondly, the exercise of judgment over facts can on occasion amount to an error of law. And we've made complaint about the way in which Dr. Lillico's evidence was treated, for example. And then in McLaren, the issues arising concerning the scope and effect of judgments of the Supreme Court and House of Lords, in that case on a different issue, and in particular how they apply in the context of collective proceedings, we treat as points of law. And so we would say that issues arising from previous case law, for example, Sainsbury's, Merrick's and Lloyd and Google, are all legitimate issues of law. And we say that applying that approach, the CAT analysis was wrong in law and contrary to the statutory objective in treating the issue of practicability of opt-in proceedings as effectively determinative, contrary to the guidance of the Supreme Court in Merrick's, rather than treating it as a plus factor to be balanced against the overall advantages of opt-out aggregate damages. And secondly, we say that wrongly and inconsistently treating access to data as another major relevant advantage of opt-in proceedings was both inconsistent and wrong for 4 reasons. One, it ignored as a balancing factor the case law of the Court of Justice, of the Supreme Court and the Court of Appeal, enumerating the countervailing advantages of opt-out proceedings for an aggregate award. It ignored case law rejecting access to data as a relevant advantage of opt-out proceedings in McLaren, of opt-in proceedings in McLaren, where Mr. Bishop was in both panels, on the basis that this was an inevitable and manageable difference between opt-out and opt-in. And we say that was correct in principle and reflects remarks that have been made by the Court of Appeal in other cases. And having made that finding, it treated funding disadvantages of opt-in as an inevitable and therefore irrelevant feature of opt-in when we say that was inconsistent. And then finally, as I've just mentioned, we say that the failure to assess Dr. Lillico's reservations about the feasibility of regression analysis or the usability of data likely to be available as against market-wide data was both wrong and premature in principle and a failure to consider a relevant consideration, but has also been shown to be wrong in principle by the outcome in Royal Mail, where the experts agreed that individual data was unlikely to be useful. And then finally, ground 4, I won't say anything about it beyond the fact that Iveco, having shown you an authority and said it was all too late, when we looked at the authority, it appeared to be a relatively pragmatic question, although the court was certainly surprised. And then Iveco itself appeared to think that pragmatism could be applied in relation to funding, but not for some reason in relation to the notice. In my submission, given the rather chaotic situation we have, whereby the order hasn't even been made, and our claim has effectively been stayed pending the outcome of this appeal, all we're really asking is that that situation should continue until the dust has settled, as it were, both in relation to funding and in relation to the way in which the RHA will advertise its opt-in claim, if that is actually what happens. But obviously our primary submission is that the debate with Mr. Flynn with respect to the court rather missed the point that their application has a basic flaw in it. And that's the problem. And that's why they've been so cagey about coming forward with any solution. Because any solution they would come forward would immediately fail for the reasons I think explored primarily in answer to questions from my Lord Justice Snowden. So that's our position. And so we would invite the court, however reluctantly, to say that overwhelmingly the best solution here will be to have 2 representative actions, with my clients representing the new trucks on an opt-out aggregate basis, representing everyone with no conflict, and Mr. Flynn representing used trucks, again with no conflict, on the basis of the quantification methodology and the pleadings advanced by the RHA and Dr. Davis since 2018. So that's my position, my Lord.
My Lord, I'm delighted to say I can reply in 2 minutes. Mr. Thompson, I accept the gauntlet that was thrown down. He said he wanted to set the record straight, and he suggested that he would put forward before you the high watermark of why I was wrong. There were 2 parts to that. One is the reply, paragraph 77 in particular, where he said it was completely wrong for me to have suggested that Dr. Lillico hadn't addressed pass-on. But of course, if one reads paragraph 77, the reference to that being tab 21 of volume 2, the supplementary bundle, page 803, of course, plays right into my hands, because what it says is that he's not addressing pass-on, and the reason for that is, quote, the time for that debate will be after pleadings and in the context of any applications for disclosure, as in the individual claim. So far from being a point in his favour, that is exactly my case. The second high watermark was said to be the response report of Dr. Lillico, which is in tab 15 of the first volume of the supplementary bundle. He invited you to look at the passage on pages 469 and 470, which I have open in front of me. But again, that plays straight into my hands, because when you read it, all he says, just above the first hole punch, is, I understand these issues are mainly for later phases, but, quote, I offer the following condensed remarks on these 2 topics. And it consists of 4 paragraphs and 1 diagram, not one single part of which is applied to this case. They could have been extracted from a textbook. They're entirely generic, and critically, they do not address at all the principal point that I was making yesterday, which is that by reference to cases such as Sainsbury's, there is an entire focus upon the PCMs, and you have to have data from them. And that leads me to the penultimate point, which is that Dr. Lillico, as I pointed out in the transcript, accepted in terms when he was asked by the tribunal that there did need to be on downstream pass-on disclosure from the PCMs themselves. That was conceded by Dr. Lillico. Nowhere is there any reference to that in the reply, in this report, or anything other than, with respect, the misconceived remarks of Dr. Lillico on the transcript where he said that would be easy to obtain, that's how these things work, which we know is wrong. And that takes me to the final remark, and then one housekeeping point, is Mr. Thompson doesn't deal with the finding in the judgment at paragraph 156. Quote, Dr. Lillico had not been asked to address this in his written report, unquote. That's by reference to downstream pass-on. That's because the generic points don't address it. And then the housekeeping point, my lord, just what I read out in open court yesterday, Dr. Grantham's report, which says we don't see any way in which this can be done on a collective basis. That's now found its way into tab 14 of the second supplementary bundle. So if you wanted to see the passage that I read out, unless I can assist further, that's all I have to say in reply. Thank you.
Mr. Harris. Mr. Jarl.
My lords, Mr. Harris in his main submissions rightly noted that the CAT in our respectful submission got a lot right in this case. And one of the things that it did get right is that it recognised that our ground of appeal raised a point of law and an important issue for the new regime. And you can see that if you go in the core bundle to its decision on its judgment on permission to appeal, which is in tab 18 and page 337, paragraph 12. It said this, it said, we should explain that we have decided to grant permission as stated above, not because we have doubts about the conclusion reached in the judgment, but because we recognise that this ground potentially raises an important issue in what is still a new regime, although the decision here was very dependent on the facts of this particular case. We think it therefore merits consideration by the Court of Appeal. Exceptionally, therefore, we grant permission on the basis of both criteria set out in CPR Rule 52.6, which are adopted by the guide. So in other words, both that it stands a reasonable prospect of success, and also because there is a compelling reason why the matter should be heard. And of course, it regarded the matter as a point of law, otherwise it shouldn't have been granting permission at all. Now, it is correct, of course, that the CAT has not made a final order, although there is an order which, as my Lord Justice Snowden observed, the relevant part of which is effectively agreed to be a fair reflection of the CAT's judgment. But again, I'm inclined to defend the CAT somewhat on this, because in fact, under the CAT's rules, Rule 107, exceptionally, appeals are not made from orders of the CAT. Appeals are made from decisions of the CAT. It's a curious exception to the general rule, at least under the terms of the CAT rules. It's CAT Rule 107. So what then is the decision or decisions of the tribunal against which we bring our ground of appeal, and in relation to which the CAT gave permission?
That's why the normal rule is the one it is.
Yes, so that
appeals are from orders. So the Court of Appeal can immediately see what it is.
Well,
the ratio of the decision.
I see that. But I think that it's
the word in the
Yes.
CPR, and I was just hunting around for a whiteboard
Yes.
and can't see it. The word decision is also used in the CPR rather curiously.
right.
But are you suggesting that, for example, somebody who doesn't like a particular finding in a judgment given by the CAT can appeal against that particular finding, saying if it could identify that it was wrong in law, even if the ultimate
Order is. I think they couldn't, my lord. I accept that.
I mean, it's an important point.
It
I
is.
think in lurking here is quite an important point for the CAT.
I think that may be. But in our submission, we say that the decision here is that against which we bring our appeal, the key decision, is that the conflict of interest that we identified does exist or may exist, that the CAT finds, but can be adequately dealt with by the RHA explaining in its Rule 81 notice that it will adopt a position on the used truck overcharge and hence resale pass-on that is based on the advice of Dr. Davis. And we say that that decision was an error of law. And the CAT, I think, recognised that it was making that decision, otherwise it wouldn't have granted us permission on a point of law.
It's 246, I mean, essentially
Yeah.
246, 247, you say is where
Absolutely.
it went wrong as a matter of law.
Correct. And the tribunal has explored the judgment in more than a little detail with Mr. Flynn, and we suggest that there are essentially three aspects to it, plus, if you like, a coda to the relevant part of the judgment. First of all, we do say that the CAT does recognise the nature of the conflict. We see that in paragraph 75, where it recognises that the higher overcharge on used trucks implies a greater level of pass-on of the overcharge on new trucks. And then the core of the judgment, at the critical stage, is paragraphs 246 to 248, which one might call its positive reasoning, where it says that because of the nature of opt-in proceedings, the class members can effectively waive the conflict here by giving informed consent. And what they would be consenting to, they say, is the RHA resolving the conflict between them on the advice of Dr. Davis. And that, it says, can be fairly disclosed by way of the Rule 81 notice. Then there's also, if you like, the negative aspect of its reasoning, which they say, well, even if used and new truck buyers had separate representation, the conflict of interest would still persist. And you've heard my submissions as to why that's plainly wrong, because separate representatives would be acting in separate capacities. And that's what you see in paragraphs 250 to 252. And then finally, if you like, there's the footnote or the coda, where they say, well, if in due course the diverging interests caused a problem, then later on, then the CAT could at that stage vary the CPO to define a subclass covering used trucks with a separate representative. But it also doubts, it says, that will ever prove necessary. And that's what you see in paragraph 255. And as I've said, the tribunal's positive argument, if you like, it can be overcome, the conflict can be overcome by the notice, is fairly reflected in the draft notice that you see in bundle E on page 19, at page 21. I don't think I need to take it up because I can apprehend that the court is all over it.
We can probably recite it to you.
Yes, but the problem with it is that it's completely unrealistic to suppose that operating on the advice of an expert, even one as distinguished as Dr. Davis, can overcome a conflict that is as clear and acute as this one. On the used truck overcharge, there just is no common interest within the class. There is only a conflicting interest within the class. It matters not at all to the existence of that conflict whether the new and used truck buyers, as Mr. Flynn pointed out, are intermediated by dealers, and nor does it matter precisely how the causal mechanisms operate. Now, it was said by Mr. Flynn that Dr. Davis will run his regression analysis, and his statement in the judgment that's quoted in paragraph 246, that he could effectively act unaffected, was unchallenged. Well, that's correct. We didn't challenge Dr. Davis's subjective views because that isn't relevant. But what we did question was how his model operates. And if I could just show you that, because you'll find it in bundle E, which is the second supplemental bundle, and you'll find our cross-examination of Dr. Davis in the first tab. And I don't want to read the whole thing to you, but just to give you the key passages. If you look at the bottom of page 8, you see I put him, and what I notice, I'm putting to him those equations that you recall that are in table 27 that I took the court to in opening. And I put to him at the bottom of page 8, the last line, and what I notice about that is that it's got a minus sign before it. Yes, it does, yes. And whereas for the fuel efficiency, there is a plus when we come to the third component. Yes, yes. And the reason it's got a minus sign is because in calculating damages to a new truck purchaser, you are subtracting, not adding, but subtracting the used truck overcharge. That is true, yes. So if you are a new truck owner, just to be clear, and you only bought new trucks, your damages go down the higher the used truck overcharge gets on your model here. On this model for the cash price, on these equations or for the cash price contracts, yes, that's correct. Yes, that's correct. And then if you go forward to page 11, Dr. Davis was speaking about a complexity in his model, and I put to him on line 8, I say, yes, so that's a complexity then in how the calculation is to be arrived at. But if I could just put it to you in general terms, if you take, for example, I think we understand it is a little bit over a third of the RHA's class that are just new truck buyers, only bought new trucks. If you calculate a higher used truck overcharge, that is going to inevitably reduce their damages. Am I right on your model here? So you are subtracting off the mitigation. So yes, it would reduce their damages. I do think yes. Dr. Davis entirely fairly and properly acknowledged the nature of the absolutely direct nature of the conflict. And this is not a speculative conflict that might arise at some point in the future. This is an actual and present conflict. And nor is it a conflict in relation to which, contrary to Mr. Flynn's submission, that there's any doubt about its materiality to the class, or at least to important sections of it. Because as I showed you, over 1/4 of the class bought only used trucks, and over 1/3 bought only new. And the difficulty with the approach of just relying on Dr. Davis is that it just doesn't account for the fact that these econometric models don't operate in a factual vacuum, and they shouldn't operate in a factual vacuum. And in fact, some of the discussion between this court and the bar has shown why one does need to bear in mind facts and common sense in the application of these models. And that is amply borne out by the Royal Mail case. Mr. Flynn suggested that there were no lessons to be drawn from that case, possibly because he suggested that the experts in it were partisan. But there was no serious suggestion that, for example, Mr. Harvey in that case acted in any way improperly. I mean, it said that they both supported their client's case, but it's not suggested that one could disregard it in that way. And his conclusion was that there was no used truck overcharge, and the tribunal accepted that there was no used truck overcharge. And I'm afraid Mr. Flynn can't exclude that Dr. Davis won't reach the same conclusion. And one can just see the sort of difficulties that would arise if this matter is left unsolved and we proceed through with no representation for the used truck owners, and we proceed through, say, disclosure, factual evidence, and then Dr. Davis presents his report, and it says, I find no used truck overcharge. And what then is that going to do to the 4,000 members of the class who at that point will realise that they have been...
Very fortiori, if there were available witness evidence or disclosure that would have supported a case that there was a used overcharge. And this is the point, isn't it?
This is absolutely.
However independent the expert,
yes,
the regression analysis is dependent upon the quality of the data that goes into it.
That's right. That's absolutely right. And the case that Mr. Flynn took, Your Lordships, took, which is the general judgment of the CAT on disclosure in the individual trucks proceedings, only goes to make the point, because what that case shows at paragraphs 34 to 35 is that the CAT doesn't typically order standard disclosure. So it's not as though you can just say, well, everybody would have to give standard disclosure and the documents will just sort of describe themselves. Rather, what happens is the two sides pick out to identify specific categories that they want, and they ask the other side for those categories. And it's usual indeed for the two adverse parties to make those applications and to have hotly contested disclosure applications. And that just what this shows is that this is just an issue that can't be glossed over. It can't be pushed properly into the long grass. It has to be grappled with, and has to be grappled with now. Now, it is right to note that the RHA made an offer in its reply in the terms that is quoted in the judgment in paragraph 253. But it's important also to appreciate the limitations of that offer, because it is not, first of all, it is not actually an offer of independent representation. It was an offer of independent advice. And the proposal was that there would be a separate team of lawyers who would effectively advise on Dr. Davis's, with an expert, who would advise on Dr. Davis's regression analysis. And that, I'm afraid, doesn't go far enough. And we picked this point up in our submissions below. If you turn, please, to volume C, volume 3 of the supplemental bundle, tab 25. And you see here, this was our skeleton argument for the hearing. And if you go, please, to page 957. And you see we note the RHA's offer at paragraph 46. And we say, however, the possibility of used truck purchasers being represented by separate lawyers and experts cannot assist if the representative giving instructions itself is one and the same. The same issues will arise, whether to pursue disclosure applications for documents that are liable to assist the one group but not the other, or whether to instruct a new expert. The RHA's proposal for a separate legal and expert team for used trucks is also entirely underdeveloped.
I mean, this is the point that I put to
Yes.
Mr. Flynn, right?
Yes.
So, I mean, do you say that it's impossible for the RHA to split itself corporately?
Yes.
Why?
Well, we say we have to see the proposal. We can't decide on that in the abstract.
That's fair enough. And one of the problems
That's
we
fair
have is
enough.
that
Yes,
maybe for
yes.
the CAT to do in the future.
Yes,
Yeah.
that's right. I mean, possibly, we can't completely exclude it, but it would have to be a properly independent person who's able, and who isn't, who, as we say, has got their own funding, and
There are. I think the point that we're putting to you is if it were the case that the RHA could, as Mr. Flynn says it could.
Yes.
Although it's not. We don't have any detail, then it would be for the CAT anyway.
yes,
If the RHA was able to put in place an appropriate Chinese wall, so that the used truck purchasers were represented by, or had as a subgroup class representative.
yes,
Two directors who had nothing whatsoever to do with the other
Yes.
part of the case.
yes.
And then the new truck owners had two directors who were nothing to do with the used truck part of
Yes.
the case. Now, whether that's possible, we don't know.
We don't know.
We don't know, absolutely right, and you'll be entitled to explore
Yes,
the as it were, the strength of the wall
yes.
in due course. But I don't think you're saying that is, as it were, completely impossible.
No, we're not saying that's completely impossible, and we never have, in fact, because if you, I think one of the passages that we put into the bundle is day 5, page 24, which were our closing submissions. And what I make clear in those submissions is that we acknowledged that you can potentially have a separate subclass.
Yeah.
We don't care whether you call it a class or a subclass. What we care is that there is a separate representative who's able to give instructions to support
Well, it's
the
It's
use
in
truck.
the guide.
Yes,
It's expressly referred to in the guide.
yes, indeed. The possibility
Would
of
the concept of a separate representative include, for this purpose, though, a Chinese wall divided representative?
Yes, there would have to be. Yes, I think yes, there would have to be a complete split.
I mean, and if this didn't work,
Yes.
if it was remitted to CAT and it didn't work, then we're into Mr. UKTC's territory, aren't we? Mr. Thompson's
Well,
solutions.
we're not sure that it necessarily drives you into the arms of UKTC because because it could
I mean,
be.
his solution is to have two class reps,
Well, there,
him and the RHA, one for
well,
new and
I
one for
think
used.
the CAT's decision was multifactorial, as Mr. Singler's rightly said, and that there are a number of factors which made the CAT favour the RHA over the UKTC. So I think that is a matter for the CAT's discretion.
Does the CAT itself contemplates in paragraph 255 authorising somebody other than RHA to act for that subclass?
Yes. So
So-
it would have to be a person who is
UKTC could be invited to act for the used purchasers.
My lord, I don't want. I can't say that one could tie the hands of the cat. But,
Sorry, how can you?
Be acting for the
Hey,
new,
you
for the
have
new,
to act for the new ones because it's not.
which is, I think, is
it's
Mr.
not
Thompson's
issued.
point.
it's not issued a claim.
It's not issued a claim form on
That's
behalf of the used ones. So
That's right.
it would have problems, I think. I mean, this is.
I'm just, this is what the CAT says in 255.
Yes.
For the,
Yes.
I mean, by definition, they're referring to the used purchasers.
They are a defender because they
They haven't really grappled with all the sorts of complications that have been identified for us.
Yes. But as Mr. Pickford submitted, the answer here is remittal, and one needs to see whether the RHA can considerably improve their game, really. And that's what we said at first instance as well. And we know this may all be very inconvenient, and we're terribly sorry about that. But it's not realistically going to go away.
Well,
And it's fundamental.
Your submission is really the one that, this is not the CAT, one thing the CAT did get wrong, you say, is saying, well, this is all a conflict, this may be a conflict in the future. Because you say, no, this is a conflict now.
Yes, well, that's right. It is a
Because you may not have yet pleaded a defence, but you made it perfectly clear
yes.
that the issue pass on does arise. If the issue pass on arises, then there is a conflict.
Yes, and well, indeed, it is
Or
intrinsic.
whether it's an
intrinsic-
actual conflict or a
Yes,
potential conflict,
That's right.
sufficiently identified that the issue should be dealt with now.
Yes, indeed, and it's intrinsic indeed in the fact that the RHA itself pleads a used truck overcharge, because that is effectively saying, or possibility of it.
The error of law you say that leads to this is the CAT telling itself that the issue as between used and new truck purchasers can be addressed by Dr. Davis acting in the way described
Yes,
in paragraph 246, 247.
that's correct. My lords, unless you have any other questions,
No, thank you.
My lords, first I'm going to address the issue that Mr. Flynn raised, where he said that the conflict that we identify is not as acute as we claim, and that on some points it doesn't arise at all. And I can make 4 very short points in response to that. Firstly, the RHA's opening submission in this regard rested on the contention that some new truck buyers will have sold their trucks to used truck purchasers outside the class, and conversely some used truck buyers will have bought their used trucks from outside the class. And he suggests that that lessens the conflict, and that's entirely wrong, and we can see it this way. Let's assume, in the RHA's favour, that there is not a single intra-class transaction at all, so that every single used truck owner bought their truck from someone outside the class. That makes no difference whatsoever to the existence of the conflict, because the claim in respect of all of the used trucks is still maximised by showing that the effect of the unlawful conduct on used truck prices was as high as possible. And the claim in respect of all new trucks is maximised by showing that the effect of the unlawful conduct on used truck prices was as low as possible. How many intra-class transactions there actually were is simply irrelevant to that calculus. So that point, with respect to Mr. Flynn, doesn't go anywhere. Second, he told the court in answer to a question from the Chancellor that there was no conflict of interest at all between new truck purchasers and used truck purchasers arising from the fact that the overcharge on new trucks would tend to reduce the volume of new trucks in the market. It was a point that was discussed yesterday and that we return to today. And of course, as the Chancellor pointed out today, that is precisely where the conflict bites. It's in the measurement of that issue. There may not be any, or there might not be very much conflict about the underlying economic theory, but there's a huge amount of conflict in terms of the measurement of that issue, because that's where the interest of those different groups is pitted against one another. Third point, Mr. Flynn sought to downplay the conflict by the somewhat vague submission that averaging somehow reduces it. There's no evidence that averaging reduces it, and in my submission, that's entirely wrong, and I'd like to illustrate it this way. Let's take the value for used truck overcharge that Dr. Davis hands down from high, and let's suppose there is only one average value for that used truck overcharge across the entire claim. Let's call that X. Now, let's suppose we increase X a bit, but leave everything else the same. What that means is that the claimant group could then be divided into three. There'll be those that benefit from the increase in X, there'll be those that suffer from the increase in X, and there'll be those that will be indifferent to the increase in X. And the only people who could possibly be indifferent to the increase in X are those new truck purchasers that did not have any resale of any truck during the 18 years over which it is claimed there would have been effects. That is likely to be a de minimis group. We have no evidence from the RHA suggesting it's a material group at all. Common sense tells us it's going to be very small. But even if there are some people in that group, everyone else who either was involved in reselling new trucks that they bought is going to be affected by the used truck price.
Is there in fact any evidence at all about whether or not the new truck purchasers did resell their trucks? I say the new truck purchasers in either of the two classes did resell their trucks. Because I mean, obviously in Royal Mail and BT, they didn't. BT certainly didn't. They just ran them into the ground and then scrapped them. And I don't know.
We haven't got there.
I have no idea whether fleet owners, for example, keep their trucks for 10 years and then sell them.
My lord, I mean, I think it is in the evidence somewhere, although the exact reference I can't give you. Ordinarily what happens is there is buyback. So the contracts exist such that you own the truck for a certain amount of time, and then there is resale. It's bought back by the OEM. So we say bought by the dealer or by the OEM. So we say there will be resale, and therefore that is going to be obviously a highly material issue in the proceedings. So
is there a possible fourth group of people who would be indifferent? People who both buy used trucks and used trucks?
My respectful submission, no, they won't be indifferent. If you both bought new trucks and had some resale, and you also bought used trucks.
I mean, depending on how the balance of your purchases, you could be, broadly speaking, unaffected.
Well, and it is true that there may be some people who are just perfectly balanced in relation to the particular number that they bought on one side and the other. That would be happenstance. And you wouldn't have to change my value of X, the average value, very much for ultimately them to tip one way or the other. So my submission, actually, the only group that could ever really be indifferent is someone who never resold its trucks.
Indifferent as opposed to unaffected.
Yeah.
Yes. Okay, got it.
Yeah. So in fact, far from this being a small issue that's only perhaps going to affect a few people, this is going to affect, plainly, the vast majority, if not all, of the class. So that's the first point I wanted to make on Mr. Flynn's submissions in that regard. Secondly, I think this is probably a point that the court has, but it's just to add to something that Mr. Jarl said. There was a discussion about 10 minutes ago with the court where Mr. Joel made the correct submission that, of course, the econometrics all depend on the facts, and so there will be fights about the facts. Also, the econometrics depends on the judgments that the econometrician, him or herself, employs in their modelling. We see that clearly at paragraph 235 of Royal Mail, whether it's about exchange rates or the effects of the financial crisis, etc. So it's not even that if you've got a single set of facts about which there was no debate, you could then say, oh well, there's then an econometric answer.
It's not just
such thing at
data,
all.
it's assumptions that are made by the expert based upon his or her.
Absolutely, my
within
lord.
reasonable bounds. You can have the variant maybe between 1 and 10. It may be reasonable to pick 5, but if you want to increase the damages of one category, you reasonably pick 7 or 2.
Quite.
And all reasonable, all rational.
Yeah.
Quite. So
Key. That's the real difficulty with having one expert they can take entirely rational, reasonable and objective decisions and yet still come out with 2, 3, 4 different results.
Exactly, and particularly with respect to Dr. Davies, without questioning his impartiality at all, this expert doesn't seem to fully appreciate that. He seems to think that he can just choose the number and he will be right. And sometimes experts do think they're always right, but as the court rightly points out, there may be other experts who also think they're right, who are just as reasonable in their position. So that is my submissions on that. Next point is that the conflict, if the court is with me in the points that I just made, we know that the conflict bites today. And that's because by seeking to deny and downplay the conflict of interest, the RHA has, in this very hearing, with respect, not been representing the interests of each of those two groups to the maximum extent possible. For instance, the RHA simply doesn't recognise some of the conflicts that we say, it denies them. And in relation to that, it says, oh, well, we'll just muddle along and see if there's a conflict after all, and perhaps it won't arise. That is obviously totally inadequate when we can all see that the conflict arises right now. And we have no idea when Mr. Flynn might deploy his clean team, because he doesn't think that there is a serious conflict, and there obviously is. So that's my submission on that. Next then, the issue of the notice. One footnote point, and I think Lord Justice Snowden, your Lordship has this, but there was a reference to it being agreed. It was obviously agreed within the context of the CAT being right. And we expressly reserved our position to say, obviously, we say the CAT is wrong.
But in any event, it doesn't matter, because ultimately it's a matter for the CAT as to what form the notice should take. The CAT has said in terms that it will be vigilant to police the form of the notice.
Yeah, I meant it's agreed as a reflection of the CAT's judgment. But
Indeed.
you say the CAT's judgment is wrong.
Indeed.
Yeah.
So if I can just develop that point, just a related point slightly further. If I could take the court, please, to the authorities bundle. I think it's probably 9 of yours. Generally, the formula seems to be, sorry, possibly 12 of yours, actually. Add 1 and double. Anyway, it's tab 69. And so this is an extract from the SRA Code of Conduct for Solicitors. And I'm looking at page 2916. The 6 has been obscured in mine, unfortunately, by a whole bunch. And in particular, conflicts of interest, paragraph 6.2. Does the court have that? So it says here, you do not act in relation to a matter or particular aspect of it if you have a conflict of interest, and critical words I'm going to emphasise here, or a significant risk of such a conflict in relation to that matter or aspect of it, unless, and then there are some conditions. So 2 conditions are, firstly, the clients have a substantially common interest. Secondly, or alternatively, the clients are competing for the same objective. Now, my submission would be those don't actually apply here, but let's assume in favour of the RHA that they, and it's those lawyers acting for it, that they do. There are further conditions that must be met, and those are that all clients have given informed consent, given or evidenced in writing, and that you are satisfied, that's 3, that it's reasonable for you to act for all the clients. Now, what that means is explained in the Law Society guidelines, which are found in tab 81. I hope the court has 81. It's within a separate additional authorities bundle.
It came this morning.
I'm very grateful. So,
Why are you showing us this? Are you showing us to say this could never be managed at all by the CAT if we remit it to the CAT?
no,
Or you're just sort of basically trailing the sort of considerations that would have to be had in mind?
it's actually somewhere between those. So my submission is that the issue that we are now faced with could never be resolved simply by sending a notice out to all of the members of the RHA, everyone who signed up as well, saying there might be this conflict or there is a conflict, but please say you're happy to act. If I may, I'm going to show you paragraph 5.3 of the guidance, which makes clear what the lawyers acting need to be satisfied of, and that makes it clear that there is only one solution here, if there is a solution at all, and that is a strict division within the RHA so that there are two separate groups.
The Chinese wall.
Exactly, and I can demonstrate that in terms by, if one looks at 5.3, you see that these conditions, which must be met, if either of the exceptions of the conflicts of rule to be relied on, are that, and then that repeats what I showed the court before. And then we have an explanation of what informed consent means. The requirement for informed consent means that clients must understand the relevant issues and the implications of giving such consent, and you should obtain their consent in writing or have some other written evidence of their consent to you acting. You should consider whether your client is a sophisticated user of legal services, such that they will be able to understand the implications of you acting in these circumstances, and therefore be in a position to give informed consent. You should document this carefully, etc. But my submission is we have a class here of many thousands of people who may or may not be sophisticated users of legal services. I think we can probably rely on the fact that there will be many of them that are not. And so it's simply not possible for the RHA's lawyers to satisfy their own duties to their clients, that each one of their clients fully understands the conflict, if in fact there is going to be a conflict. There is only one solution, which is to get rid of the conflict by saying, okay, there is no conflict anymore, because if you're a used truck buyer, sign up here to our used truck claim. And or if you're a new truck buyer, sign up here to our new truck claim. At that point, the conflict that we have identified goes away. But what would not be satisfactory is what the RHA envisage and what the tribunal seem to envisage is that everyone within this class might just be written to and told that, well, here it is, consent. Indeed, it's notable. I mean,
say here it is consent. I mean, one of the problems is that the CAT really says two different things, doesn't it? It starts off with 246 and 247, which see from which the notice that's been drafted seems to derive, which is just saying, leave this all to Dr. Davis.
Yeah.
He'll sort it out for you, which is plainly not an answer.
Yeah.
But the CAT then goes on later in 253 to 255 to say, well, there is this offer of, I mean, leave to one side whether it's separate representation or separate advice. I follow that point to Mr. Giles, but assume for the moment that what's envisaged is separate representation of the claim we've been debating. The problem with the CAT's approach is that it says, well, that's not for now, that's for later.
Mm-hmm.
So what I think we've been envisaging is that is either there is an actual or potential conflict which has to be addressed now.
Yes.
So that regime has to be put in place.
Exactly.
And that the notice tells the proposed members of the overall class that is what is, that there is a conflict or an actual potential conflict, and this is the way in which they propose to deal with it.
Yes, or at least there would be, but for the regime that they're putting in place.
I follow that.
That's my point. The regime basically has to tackle the conflict. What you can't have is a situation where you have potentially not sophisticated people signing up to something without having fully understood that they're actually buying into a conflict. That's the point. Very, very quickly, because I'm aware of the time, and there's just a couple more short points. It's been suggested a number of times during this hearing that our interest in this point is essentially just to make life difficult for the RHA, and that is not right. We have a strong and legitimate non-Machiavellian interest in used truck buyers being properly and separately represented. Why? Because although obviously on some issues we are very far apart on whether there was any effect at all of the unlawful conduct, on other issues we share a very close case with those used truck purchasers, and they were by definition the buyers in the relevant transaction. So they will be the people who have the best evidence about the transactions and about their propensity to buy and whether they thought, how they would react to a change in price of new trucks in terms of their purchases of used trucks. Those are all things that they can very usefully contribute to the proceedings, both for them and as a side wind from which we may benefit. There's nothing Machiavellian about that. We want the people who have the best evidence on an issue that may also advantage us to participate properly and fully and separately represented in the litigation. So that's my submission on that issue. And then just two more points and then a conclusion. To address a point that was raised by Lord Justice Snowden about the legal framing here. I think it was suggested, my Lord, a little earlier on today, that this doesn't go to the certification in this issue. In my submission, it does go to certification because one of the things that needs to be satisfied, the tribunal needs to be satisfied of, because of Rule 78(2)A, is that the RHA can fairly and adequately act in the interests of the class members. And given the structure that it has currently proposed for bringing forward this litigation, it cannot do that. It could only do that if there was a radical restructuring along the lines that the court, I think, has in mind.
But what could happen, and this is just a very broad brush, is if, and I speak just for myself in putting forward this as a proposition, if the court was not at the moment satisfied with the RHA's structure for dealing with the conflict, but remitted it to the CAT for the RHA to consider it and put forward a proposal to deal with the conflict. Now, one of two results is going to happen. Either the RHA is going to satisfy the CAT that it can deal with the conflict within the confines of its own currently structured collective proceedings, or it's going to fail to satisfy the CAT that it can deal with the conflict, in which case the CAT has the option of certifying to class representatives, i.e. somebody for the new, which must potentially step forward UKTC, and the RHA acting for the used buyers. That's Mr. Thompson's suggestion.
Yes. I don't think I disagree with anything that my Lord has put to me. I think my response would be that those points are true, but they don't alter the fact that this does go to certification of the currently proposed class.
Correct.
And the structure that has been put in place for it. That's my only point there.
Yeah, fine.
Yes.
Or
Or in fact, technically, the CAT could amend the certification for the RHA, assuming it had made an order, which we know it hasn't. It could amend the certification. I mean, in a normal case, let's assume the CAT actually makes an order, and this point arises, and it hasn't killed off the alternative by dismissing it. It would amend the CPO certification, wouldn't it, and then certify the second-class representative waiting in the wings.
that is one potential route. I think in this circumstance, obviously, our submission is that the only thing that's currently before this court doesn't work. So the certification order.
Currently, the CAT hasn't actually certified anybody.
So
I mean,
court.
if what I understand to be the correct is correct.
That's right. So I would be asking this court to make clear that what is currently there does not work, and it would be for the RHA to go away and say, bearing in mind what this court has said, come up with a new plan. We can then make submissions on that new plan. It might be we say, yes, it's fine, or it might be say, actually, you need to change it still because you haven't done enough. And then the CAT would need to consider its certification decision in the light of all of that.
Yeah.
Final footnote point. It was suggested very fairly in response to a question on the Who from the court by Mr. Joel that even in relation to the CAT, if there is an order, in an order, if there is an order, you cannot appeal against the judgment rather than the order. There is actually case law to the contrary. So just from a footnote point, it's Ofcom and Flow Telecom, 2009, EWCA Civ 47. It's an unusual case, but the circumstances in which that arose is where the tribunal took a view on very important legislation involving GSM gateways and said, here's why we dismissed this appeal, it's for this reason. And Ofcom and other interested parties said, we're glad that you dismissed this application, but I'm afraid you got the law really wrong. And if the law is thought to be what you said it would be, that's going to cause lots of problems. So please can we appeal? And the Court of Appeal entertained that appeal. So that's an example, but it is relatively rare.
Yeah.
So,
Okay.
in conclusion, my lords, my submission is that the RHA have, by putting their heads in the sand as regards the potential, as regards the actual conflict in their claim, begun to get themselves into a mess. And this court needs to rescue that and regularise the proceedings. They are driven to denying or downplaying the conflict, and if they're wrong about that, that calls into question how they can properly and fully advance the interests of both of the groups of claimants that they claim to represent. Because surely the fundamental first step in advancing your client's interests is to appreciate precisely what those interests are. And the court knows what my proposed solution is. We've debated it, so I don't propose to repeat that. Unless there's any further points in which I can assist the court, those are my submissions for now.
My lord, I'm not making another submission, but your lordship asked whether there was any evidence at all about used trucks, whether they were sold. I did mention it very briefly in my submissions, but it possibly went by. It's, I think, Dr. Davis's first report at pages 148.1 to 150 gives some rather rudimentary evidence based on sampling and data. That's the only thing I've seen to date.
Good.
Sorry, I do beg the indulgence of the court. Behind me, they have just pointed out that in response, there was a question from the Chancellor about whether BT resold its trucks, or a statement that it didn't. Paragraph 512 of the Royal Mail judgment explains that there were resold trucks in that case as well.
There were some, yes, but I think there was evidence that nearly all of them were scrapped.
I'm
something yesterday. Anyway, it doesn't matter.
It's not a big point. I'm simply drawing it.
My lord, I think I would be entitled to reply to what Mr. Pickford put forward in relation to the SRA, but since in effect I think he was trailing submissions that he will make at another point, that I will not do so. Simply to point out that the client for the solicitors here is the RHA and not every member of the class. But those, I think, are for another day.
Well, I don't think it was being put forward as a criticism of your instructing solicitors, or I think it was really being simply saying that you know, this is what the position would be for firm solicitors, and therefore, by analogy, the same.
In a new world. So I think it's trailing what would be argued in remission, and so I won't
understood.
I won't take up more of the court's time. Thank you.
Right. Well, unless anybody has anything else to say, we will reserve our judgment, obviously, and we will provide it in draft in due course. If you can restrict your responses to pointing out any typographical and similar errors rather than writing the court to reconsider its decision on any point, or its order on any point. If you could possibly agree a formal order at the same time, then we'd be grateful. If you can't, we'll deal with any issues on paper. And it only remains for me, on behalf of the court, to thank all of you, that's all counsel and solicitors and on all sides, and the teams generally, for an extremely well presented appeal. It ran slightly longer than we'd been told, but nonetheless it's been extremely well presented. You've given us some